Hello there. Steve here. Welcome back to another Sleepy Steve story. I hope you are tucked in, comfortable, and warm. Go on. Adjust your pillow if you need to. Let your shoulders drop, and allow the day to slow down around you, because there is absolutely no rush tonight. None at all. Before we drift off tonight, remember to subscribe to help Steve-O out, and I will keep making more sleepy stories to help you study gently, revise quietly, and settle your mind at the end of the day. We are going to be exploring VCE Legal Studies, Unit 3, Area of Study 1, and our focus is sanctions and sentencing in the Victorian criminal justice system. This means we are moving to the point in a criminal case where guilt has already been established, either because the accused person has pleaded guilty or because the prosecution has proven guilt beyond reasonable doubt, and the court must now decide what sanction should be imposed. Tonight, we will move slowly through the purposes of sanctions, including punishment, deterrence, denunciation, protection, and rehabilitation, and then we will look carefully at 3 common sanctions in Victoria: fines, community correction orders, and imprisonment. We will also think about sentencing factors, the impact of sanctions on offenders, victims, and the community, and the way sentencing connects back to the principles of justice, fairness, equality, and access. You do not need to memorize all of this right now. You do not need to write anything down. Just let the ideas arrive gently, one at a time, as though they are being placed carefully on a quiet desk beneath a warm lamp. Take a slow breath in with me now, and let it go. Let the tension leave your hands. Let your eyes become heavy. Let your breathing find its own calm rhythm. Imagine now that we are sitting in a quiet study room late at night, with a soft lamp glowing beside a stack of legal studies notes, while outside the window the street is dark and still, and the sound of distant rain moves gently across the roof. There is a notebook open in front of us, and at the top of the page are the words sanctions and sentencing. A sanction is a penalty imposed by a court on an offender after they have been found guilty of a crime. That detail matters because a sanction does not come at the beginning of the process, and it does not come merely because someone has been accused. A sanction can only follow after guilt has been properly established. And this links back to the presumption of innocence, the burden of proof, and the standard of proof in criminal cases. Once guilt has been established, the court must decide what consequence is appropriate, and this decision is called sentencing. Sentencing is not random. It is not simply about choosing the harshest possible response, or the easiest possible response, or the response that seems most satisfying in the moment. Sentencing requires the court to consider the purposes of sanctions, the seriousness of the offending, the circumstances of the offender, the impact on the victim, and the need to protect the community while still acting according to law. Let us begin with the purposes of sanctions. The first purpose is punishment. Punishment means that the sanction should impose a penalty on the offender because they have committed a crime, and the punishment should reflect the seriousness of the offending. This does not mean revenge. In a legal system, punishment is meant to be lawful, measured, and imposed by a court, rather than by private anger or public pressure. Punishment recognizes that a criminal wrong has occurred, that harm may have been caused, and that the offender should experience a consequence because their behavior breached the criminal law. A fine may punish by requiring the offender to pay money. A community correction order may punish by restricting the offender's liberty and requiring them to comply with conditions. Imprisonment may punish by removing the offender's freedom for a period of time. The important point is that punishment is about holding the offender accountable while still remaining within the controlled and careful framework of the law. Take another slow breath now, in and out. The second purpose is deterrence. Deterrence means discouraging future offending. There are two types to remember: specific deterrence and general deterrence. Specific deterrence is about discouraging the particular offender from committing further crimes in the future. If an offender receives a sanction and understands that their behavior has serious consequences, the court may hope that the offender will be less likely to re-offend. General deterrence is slightly different because it is aimed at the wider community. It sends a message to other people that if they commit similar offenses, they may face similar consequences. So, when you think of deterrence, think of two directions. One direction points back to the offender, encouraging that person not to offend again, and the other direction points outward to the community, warning others that criminal conduct can lead to serious penalties. Specific deterrence. General deterrence. The words are simple but important. The third purpose is denunciation. Denunciation means that the court uses the sanction to show disapproval of the offender's conduct. It is the legal system saying, calmly but firmly, that the behavior was unacceptable. Denunciation matters because some crimes do not only harm an individual person, but also offend the values of the community. Through denunciation, the court expresses that certain conduct is wrong, harmful, and not tolerated by society. Again, this is not the same as uncontrolled anger. It is a formal statement of disapproval through sentencing. The court does not simply punish the offender. It also communicates that the behavior breached standards that the community expects people to respect. The fourth purpose is protection. Protection means protecting the community from the offender. Sometimes a sanction may protect the community by physically removing the offender from society, as imprisonment does. Sometimes a sanction may protect the community through conditions, supervision, treatment, or restrictions, such as those that may be attached to a community correction order. Protection is especially important where the offender poses a continuing risk to others, but it must still be balanced with the other purposes of sanctions and the rights of the offender. A legal system must consider safety, but it must also avoid assuming that every offender requires the same response. The fifth purpose is rehabilitation. Rehabilitation means helping the offender change their behavior so that they can return to the community and avoid reoffending in the future. This can involve treatment, education, counseling, support programs, drug and alcohol programs, mental health support, anger management programs, employment assistance, or other conditions that address the reasons behind the offending. Rehabilitation is different from punishment, although the same sanction may serve both purposes. A community correction order, for example, may punish the offender through restrictions and requirements, while also supporting rehabilitation through treatment or programs. Even imprisonment may attempt rehabilitation through programs offered in custody, although whether imprisonment successfully achieves rehabilitation can be debated. So, if we gently list the 5 purposes again, we have punishment, deterrence, denunciation, protection, and rehabilitation. Punishment holds the offender accountable. Deterrence discourages future offending. Denunciation shows community disapproval. Protection aims to keep the community safe. Rehabilitation aims to help the offender change. Let those 5 purposes rest quietly in your mind. Punishment, deterrence, denunciation, protection, rehabilitation. Now, let us look at the main sanctions. The first is a fine. A fine is a financial penalty imposed by the court, where the offender is ordered to pay money. Fines are often used for less serious offenses, and they can be relatively quick, practical, and inexpensive compared with more severe sanctions. A fine can achieve punishment because the offender must pay money as a consequence of the offense. A fine can also contribute to deterrence because the offender and others may want to avoid the financial cost of offending. However, fines have limits. A fine may affect people differently depending on their financial circumstances because the same amount of money may be a minor inconvenience to one person and a serious burden to another. This creates questions about equality and fairness. A fine may also be limited in its ability to rehabilitate because paying money does not necessarily address the underlying causes of the offending. So when evaluating fines, remember that they may be useful, efficient, and suitable for less serious offending, but they may not always affect offenders equally, and they may not always change future behavior. The second sanction is a community correction order. A community correction order, often called a CCO, allows an offender to remain in the community while following conditions imposed by the court. This is important because a CCO can be flexible. It may include supervision. It may include unpaid community work. It may include treatment and rehabilitation programs. It may include restrictions about where the offender can go, who they can contact, or what activities they can undertake. A CCO can punish because it restricts the offender's freedom and requires them to comply with court-ordered conditions. It can protect the community because the offender may be supervised and required to follow limits on their behavior. It can deter because breaching the order may lead to further consequences. And it can support rehabilitation because the conditions can be designed to address the causes of the offending. This is why community correction orders are often seen as more flexible than fines or imprisonment. They can be tailored to the offender and the offense, but CCOs also have limits. They rely on compliance. They require resources. They require supervision and programs to be available. And some people may feel that a CCO is not serious enough for particular offenses, especially where significant harm has been caused. So, when evaluating a community correction order, think about balance. It may be flexible and rehabilitative, but it depends on proper monitoring, appropriate conditions, and the offender's willingness to comply. Take a quiet breath now and let your body settle a little deeper. The third sanction is imprisonment. Imprisonment is one of the most severe sanctions because it removes the offender's freedom and places them in custody for a period of time. Imprisonment can achieve punishment very strongly because loss of liberty is a serious consequence. It can achieve protection because the offender is physically separated from the community while they are imprisoned. It can achieve denunciation because it sends a strong message that the behavior was serious and unacceptable. It may also contribute to general deterrence because members of the community may be discouraged from committing similar offenses if they know imprisonment is possible. However, imprisonment has significant limits. It is expensive. It can separate offenders from family, work, education, and community support. It may expose offenders to negative influences. It may not always rehabilitate offenders effectively, and once an offender is released, they may face barriers to employment, housing, and reintegration, which can make rehabilitation more difficult. This does not mean imprisonment is never appropriate. For serious offenses, repeat offending, or situations where the community needs protection, imprisonment may be seen as necessary. But from a legal studies point of view, we must evaluate both the strengths and weaknesses. Imprisonment may punish, protect, and denounce strongly, but it may be limited in achieving rehabilitation, and it can raise concerns about cost, delay, overcrowding, and the long-term effects on offenders and their families. Now, sentencing is not only about choosing one sanction from a list. Courts must consider sentencing factors. These factors help the court decide what sanction and what level of sanction is appropriate in the particular case. The seriousness of the offense is important. More serious offenses generally call for more serious sanctions. The offender's culpability may matter because the court may consider the offender's level of responsibility and the circumstances of the offending. The impact on the victim may matter because sentencing should recognize the harm caused by the crime. Prior offending may matter because a person with a history of similar offending may be treated differently from a first-time offender. A guilty plea may matter because it can save time, reduce stress for victims and witnesses, and show some acceptance of responsibility. Remorse may matter because genuine remorse may suggest that rehabilitation is more likely. The offender's personal circumstances may also matter, including age, background, health, mental health, family responsibilities, and prospects for rehabilitation. None of these factors automatically decides the sentence on its own. Instead, the court weighs them carefully. Sentencing is an exercise in judgment. It asks what consequence is proportionate, lawful, and appropriate in all the circumstances. Let us pause again. Slow breath in and gently out. Now, let us connect sanctions to the principles of justice. The first principle is fairness. Fairness in sentencing means the offender should be sentenced according to law, with relevant factors considered and irrelevant factors ignored. It also means similar cases should be treated in broadly similar ways, while still allowing the court to respond to the individual facts of the case. Fairness also matters for victims because victims may want the harm they experience to be acknowledged, and they may want the sentence to reflect the seriousness of the offending. However, fairness can be challenged if sentencing is difficult to understand, if delays are long, if the offender cannot access legal advice, or if the sentence feels inconsistent with other similar cases. The second principle is equality. Equality means people should be treated equally before the law and should not face unfair discrimination or disadvantage. In sentencing, equality can be difficult because offenders do not all come to court with the same resources, backgrounds, health, education, language skills, or support. A fine, for example, may not affect all offenders equally. A community correction order may depend on programs being available and accessible. Imprisonment may have different impacts on different offenders, families, and communities. This means equality is not always simple, and the court may need to consider individual circumstances while still applying the law consistently. The third principle is access. Access means people should be able to understand and participate in the legal system. In the context of sanctions and sentencing, access may involve legal representation, interpreters, support services, clear explanations of sentencing decisions, and access to rehabilitation programs. If an offender cannot understand what is happening, or if a victim cannot understand how the sentence was decided, the system may feel distant and inaccessible. If rehabilitation programs are not available, then a sentence that is meant to support rehabilitation may be less effective. If legal advice is too expensive or difficult to obtain, the offender may not be able to present relevant information properly at sentencing. So even when we talk about sanctions, we are still talking about fairness, equality, and access. They remain the quiet pillars underneath the whole criminal justice system. Now, let us think about the impact of sanctions. For offenders, sanctions can result in loss of money, loss of freedom, restrictions on movement, supervision, stress, stigma, separation from family, or opportunities for rehabilitation and change. For victims, sanctions may provide recognition of harm, a sense of accountability, or some feeling that justice has been done, although sanctions may not always repair the harm that was caused. For the community, sanctions may promote safety, confidence in the legal system, deterrence, and social order, but they may also create costs, especially where imprisonment is used heavily. A good legal studies answer often needs to recognize complexity. Sanctions are not perfect. No single sanction achieves every purpose equally well. Fines can be efficient, but may not rehabilitate. Community correction orders can be flexible, but rely on compliance and resources. Imprisonment can punish and protect, but may be costly and may not always rehabilitate. Sentencing, therefore, involves balancing different purposes, different interests, and different consequences. Now, as your body becomes heavier and the room becomes quieter, let us gather the main ideas together one more time. A sanction is a penalty imposed by a court on an offender after guilt has been established. Sentencing is the process of deciding the appropriate sanction. The 5 purposes of sanctions are punishment, deterrence, denunciation, protection, and rehabilitation. Punishment holds the offender accountable. Deterrence discourages future offending, both by the offender and by others in the community. Denunciation expresses the court's disapproval of the offending. Protection aims to keep the community safe. Rehabilitation aims to help the offender change their behavior and reduce the chance of reoffending. The key sanctions we have explored tonight are fines, community correction orders, and imprisonment. Fines require payment of money. Community correction orders allow an offender to remain in the community while following conditions. Imprisonment removes an offender's freedom by placing them in custody. Each sanction can achieve some purposes well, and each has limitations. The court must also consider sentencing factors, such as the seriousness of the offense, the impact on the victim, the offender's prior history, the offender's personal circumstances, any guilty plea, remorse, and prospects for rehabilitation. And through all of this, the criminal justice system is still guided by fairness, equality, and access. You do not need to hold on to every detail now. You have let the concepts pass through your mind gently. Sanctions, sentencing, punishment, deterrence, denunciation. protection, rehabilitation, fines, community correction orders, imprisonment, fairness, equality, access. Let the words soften now, as though they are written in pencil on a page beside a warm lamp, waiting quietly for you to return to them when you are ready. Your study is done for the day. You have done enough. Let your breathing slow. Let the rain outside become softer. Let the quiet room fade gently around you. This has been Sleepy Steve, helping you fall asleep and study. Good night.